Everyone. Today we are diving into the another powerful right under GDPR, a right that I like to call the data pause button. So I am talking about Article 18, the right to restriction of processing. This right allow you to request a limitation, a temporary hold of freeze on how an organization process your personal data under specific circumstances. It's an alternative to full deletion, which is often crucial when you are in a dispute. Think of this in this way, like normal processing. The data controller can collect, use, or analyze, share all the normal stuff. So, the restriction of processing, the data controller can still store your personal data, but they cannot further process it without your consent, except for a few limited exception. It's a stop sign for your data use. So when exactly you can hit this pause button? Under Article 18 gives you four key grounds. First is accuracy. If you believe your personal data is inaccurate, you can request a restriction. Will the controller verify its accuracy? This ensures no decision are made about you based on bad data. Second is unlawful processing. If the processing was unlawful, maybe the data was collected without proper consent, but you don't want the data erased. You can request restriction insist. This is a key difference from the data to erasure. So the third one is controller no longer needed the data, but you do. The controller may no longer need the data for its original purpose, but you require it for the establishment, exercise, and defense of legal claim. This is hugely important in any kind of litigation. Fourth one is you have objection of processing verification pending. You have objected to the processing based on legitimate interest and you are waiting for the verification of whether the controller's ground override yours. So let's look at the concrete example. Imagine an employee dispute a performance report that in her HR's profile. She knows that deleting it's a mistake, but she does not want it to use in her upcoming annual appraisal. She evoke Article 18 and request a restriction. The HR department must immediately pause its use until that performance report dispute is resolved. So see how powerful that is. You stay in control even without deleting the data. Once the restriction is in place, the data controller is severely limited. They can only process your personal data in four specific situations with your consent: for establishing, exercising, and defense of legal claim, for the protection of right of another person, for reason of important public interest. Crucially, if the restriction is going to be lifted, the controller must inform you beforehand. So, how do you make this request? You need to send a written request that clearly state the reason, the relevant data, and the duration, and of course, your identity. The controller must respond within 1 month. If they deny your request, don't stop there. You have the right to escalate to your national data protection authorities. So, to summarize this, remember that Article 18 is your right to pause processing. It's ideal during dispute or legal cases because the controller can store the data but can't use it. It is a crucial tool for you to assert control over your data. Think of a company you interact with based on the foreground we just discussed. Can you imagine a scenario where you would use Article 18? Share your thoughts in a question and answer section below. So, thank you. See you in the next lesson.